Tell me a little bit about wills in general. What is a will at the end of the day?
Yeah, so a will is essentially a document outlining what will happen after you pass away. Deal with lawyers, deal with accountants, they deal with the court if required. They're the ones that sort of take over the responsibility.
My brother-in-law is my executor. What does he have to do now? What does that mean in terms of probate process?
In the application, you have information obviously relating to the person who passed away, information about the trustee, but then the most important information that the court will worry about is the assets.
Obviously, the beneficiaries are who the assets would go to, but I would also assume, based on our conversation, the executor has a loaded role. At the end of the day, we want to make sure they are, have the capacity and the capabilities to be able to manage that entire estate. How often are these wills or power of attorneys sort of reviewed? Hi everyone, welcome to Chat with Chen. We're going to be diving into an interesting space within wills and power of attorneys. We have a very special guest here today, Gathya Manoharan, lawyer at Naval Wilson. Hi Gathya, welcome to the show.
Thank you.
Yeah, so Gathya, tell us a little bit about you and then we'll kind of get started.
Sure. So I'm a lawyer at Naval Wilson. I've been there since I was called to the bar in 2018. My primary practice is litigation, but I do also do some wills and power of estates work. And sometimes they do go hand in hand. So that's part of the reason why I do both. And I'm excited for our conversation today.
Awesome. So let's start with the will. I know it's a topic that a lot of people like to talk about. A lot of people don't like to talk about it, or some don't. Tell me a little bit about wills in general. What is a will at the end of the day?
Yeah, so a will is essentially a document outlining what will happen after you pass away. So it's usually, it's the main reason why people do it is to deal with their assets. So for example, you have children, you have a spouse, you want to decide where your assets are going to go. You can outline that in the will. The other thing that a will do is appoint someone to be your trustee. And the primary role of your trustee is essentially they step into the shoes of the estate. So what they'll do is they, deal with lawyers, deal with accountants, they deal with the court if required. They're the ones that sort of take over the responsibility. And it is a big role. So it is something that you really need to think about who you're putting into that role, which you can consider when you're drafting your will. And then the final piece is if you do have children under the age of 18, your will can appoint a guardian of your children in the event that something happens to you prior to your children turning 18. Again, that's also a really important decision because these people are essentially going to be raising your children. Obviously, you hope that doesn't happen, but in the event that it does, you want to ensure that your kids are looked after. And their transition of life after you not being here is still okay.
Gotcha. And when you said trustee, is trustee and executor essentially very similar?
Yeah, so they're interchangeable. Sorry,
Okay.
yeah, they're interchangeable. Some people will say trustee, some people will say executor, but they're essentially the same.
Got it. And I think one of the important things that I always think about is we have as human beings sometimes, we have a natural tendency to be like, hey, maybe my spouse is the executor or the trustee. If something happens to me, I want her to sort of look after it. But I think one of the most important things that we have to consider when we are sort of talking about trustees or executors is, do they have sort of the capability or the capacity to be able to do that role at the end of the day, right?
For sure. Like, especially as you get older, unfortunately, sometimes choosing your spouse doesn't always make sense. Because, for example, say you're in your 60s, okay? Again, you're hoping that this is not going to be used for a long time, but when it's used, your spouse might be in their 80s. It is a lot of work. Like I said, you're going to see accountants, you have to make sure taxes are filed, you have to deal with lawyers. If there's property that needs to be sold, you have to make sure you get a real estate agent. You have to basically do everything on behalf of the estate. So it is a lot of work. On top of that, if there's a language barrier, because you do have to interact with the courts, all of that, sometimes it doesn't always make sense to have your spouse. And at the same time, it's also a difficult time in your life. Like you just lost your partner. So because of that also, sometimes it doesn't always make sense to have your spouse as your trustee. Obviously, it makes it, like when you think about it, everything is in the family, so sometimes from that point of view it makes sense. But there are definitely factors that you should take into consideration. Like I said, age, just English language capacity to determine if it makes sense to appoint them.
And if it's usually not a spouse, I'm assuming a child or a family friend or anybody else who has the capacity could be an executor at that point?
In Ontario, as long as you are over the age of 18 and you are capable, you can be appointed as a trustee. So for example, very common people will put their siblings. So they'll say, they'll say they put their primary as their spouse, but if something happens to both of them, then it'll be their sibling. I've seen people do good friends. You can also appoint trust companies who are essentially, this is what they do as a business. Obviously, there's a cost involved, so you need to take that into consideration when making that determination. But obviously, the benefit of having a trust company is they're completely impartial, they're very professional. They, of course, will do everything as required by law and as required from a tax point of view. So sometimes that is something to take into consideration. And I've had clients where, they just don't have someone that they feel they can trust or are comfortable with being their trustee, so they'll just opt to go with a trust company. Yeah.
Awesome. And in terms of the components within a will, I know we touch base on two things really. The first one being, hey, in case something happens, how do the assets get distributed, which is what most people really think about. But there's a second part of it, which is, hey, if you are young parents or if you do have kids who are under the age of 18, who essentially become sort of their legal guardians at that point, right? It's not an easy sort of question to answer at the end of the day for most part. What do you typically see in practice when it comes to this? How are people sort of handling it? What do they sort of think about? What is the mindset like?
Yeah, so it is definitely a difficult decision because it's your child. It also applies, I know I didn't mention this earlier, but also applies to children that are incapable. So under the age of 18, but also children that are incapable. But in terms of decision making, it is definitely something that you need to think about and obviously have agreement with your spouse because of course, this isn't a situation where you guys are both not here, but it's definitely things like you also want someone who's likely younger. Because the goal, again, is that this is not being used right now, but it's going to be used at a time in the future. So if you appoint someone, like we were talking about earlier, your parents, they're a great choice. Grandparents are great. But if you are appointing someone in their 70s to take care of a young child, that's a lot of responsibility and obligation you're putting on them. Right. So things like that you need to take into consideration. The biggest one I usually see are siblings, because usually they have children that will be in similar ages to your own children. So it kind of makes the integration a little bit easier. So say, for example, I have 2 kids and my sibling has 2 kids and then I pass away. For my sibling, of course, 4 children is a lot, but it's just an easier transition. Our families probably already know each other. We're very close. She's my sister or brother. So things like that is something, definitely something where you feel comfortable. Of course, you're not here in that scenario, but you are comfortable with that decision and know that they're going to take care of your child. They also will the financial part will come to them as well, because any your estate will pay money for them to take care of your children, essentially, or costs and expenses related to your child. So that's also something that they'd be responsible for. So it is someone that you want to make sure you can trust in that scenario as well.
So, and 2 things, just to clarify, I'm assuming really the distribution of assets in case something happens to you, that can really happen at the time of the first death of a spouse per se, but usually the legal guardianship, I'm assuming in most cases, really applies when there's the death of sort of both spouses at the end of the day, right? I'm assuming typically if something happens to me, my spouse will sort of obviously take care of the child, but it's really when both spouses are gone at the end of the day.
Yes, for sure. So in a scenario when if one parent dies, like you said, the other spouse becomes the legal guardian by default because they're a parent. But yes, this is in a scenario where both spouses have passed away.
And I think it's important that one of the things that you mentioned, which is always important to sort of address, is, hey, at the end of the day, whether we like it or not, in case of death of both parents, somebody else has to sort of take on that responsibility. But we also want to make sure that it's not sort of burdensome at the end of the day for whether it be my sister or my brother, at the end of the day, the sibling shouldn't be burdened. So we have to make sure from a financial perspective, at the least, we're setting them up for success in that aspect of it at the end of the day, right?
Oh yeah, for sure. Like children aren't cheap, especially if you already have your own. For you to now have to take care of someone else's child from a financial point alone, it's a lot of work, right? So you want to ensure that you do, leave adequately for them to take care of your children financially.
Absolutely. Gathya, in terms of secondary will, I know that term gets thrown around sometimes. Can you maybe enlighten us a little bit about what is a secondary will, in what kind of circumstances would that be used?
So secondary wills are often used for assets that you don't need to probate. So the probate process is basically the process of if you pass away with the will, the probate process is essentially the court validating your will. So what you do is whoever's listed as your trustee makes an application to the court to essentially get the court's approval that you are the trustee of this estate, right? So assets that need to be probated are, property, like real property, bank accounts, savings accounts, stuff like that, financial assets that you have. But not everything needs to be probated. So for example, if you hold, say you have a company, you're say a contractor, let's use a simple one, and you run your business through a corporation and you are the sole shareholder of that corporation. You can put those shares, like you can distribute those shares in a secondary will, and then the benefit of that is because it doesn't need to be probated, you won't have to pay the estate administration tax on those assets. So the estate administration tax is a tax that you pay when you are applying to become a trustee of someone's estate. So it's calculated at $15 for every $1,000 that estate is valued, minus the first $50,000. So starting from after $50,000, it's $15. So that number can significantly go up depending on how your assets are sort of outlined. So if you are able to do things like put your shares in a secondary will, then your estate won't have to pay the tax on the value of those shares. So it's normally in a sense, it's basically any assets that don't need to be probated can go in your secondary will.
Got it. So a couple of things that you mentioned. So we'll touch base on all of them. The probate fees that you talked about, or probate fees or estate administration tax on, we'll jump on a wide variety of things. Is that sort of universal right across Canada, or do each provinces have different fees, if I'm not mistaken?
So each province has different ones. In Ontario, it's governed by, like I said, it is $15 for every $1,000 of the estate, not including the first $50,000.
Gotcha. And so just to sort of touch base on the secondary will before we sort of move on, what is the reason why, for example, shares of a corporation does not need to be probated versus, let's say, a home or a real property may need to be probated per se?
So things like real property, it's twofold. One is, so let's take money in the bank, for example, okay? If you have money in the bank and you pass away, and then your estate trustee shows up to the bank and says, look, my name is on this will as the trustee, like give me access to the funds. The bank is not all, like the bank wants authority to act, right? So nothing is more of an authority than a document from the court saying, listen, look, this is the estate trustee.
Got it.
So a lot of the times, like even from a practical point of view, you'll need to probate the will because you'll have institutions such as a bank that won't let you have access to these, the assets without sort of that authority. With respect to like assets that don't need to be probated, something like shares in a corporation, because of the fact that it's an internal thing. Like I'm not talking about public shares, I'm talking about private shares. Because there's also other mechanisms to deal with that. So for example, which I know is going to be a conversation, shareholder agreements. You can dictate in your shareholder agreement how your shares are going to pass after you. So because you already have that internal mechanism dealing with what will happen to those shares, you don't need to go through the formal probate process of that.
Got it. Okay, so let's just jump right into the probate process. What does probate process really mean? I mean, I know, and I'll walk through the scenario. Let's say, I have a will today. God forbid, if something happens to me, I passed away today. And my brother-in-law is my executor. What does he have to do now? What does that mean in terms of probate process?
Sure. So, like I said, probating is essentially the court's validation of the will and whoever it's appointing as the trustee. So in this scenario, what would have to happen is an application has to be made to the court to essentially validate this will. In the application, you have information obviously relating to the person who passed away, information about the trustee, but then the most important information that the court will worry about is the assets. So you'll have to do a valuation of the asset. So for example, if there's real property, I'll tell my clients, like, you need to do an appraisal of the property. If there's money in the bank, usually you can go to the bank as and sort of ask them for a summary of all the financial products that they hold at whatever bank. And then the other thing that the court really worries about is to ensure that everyone who is entitled to notice, being the beneficiaries, are aware that A, the person has passed away, and B, that whatever their entitlement under the will is. So for example, it's not really a scenario that a lot of people deal with, because a lot of people do say, listen, it's going to go to my spouse, if not my kids. Like, there's not many people involved. But you do have, going back to the example of if it was your estate, so your brother, if he was the estate trustee, he would make the application, give notice to everyone who's required, and then file the application with the court alongside the funds for the estate administration tax. Probating a will is a very administrative process. So long as no one is challenging your authority, and when I say challenging, either they're saying the will is not valid, or they're saying they, for whatever reason, think that you're not going to do a good job, you're going to steal money or something. But otherwise, it's a very administrative process. It's paperwork and the court's time. So it's just the court's ability to process applications. So that's essentially how the probate process works. So what will happen is you file that application, and then the court gives you a certificate which has the court seal on it, which essentially says so-and-so is the trustee of the estate of the deceased. And this is the most, not the most valid, this is the valid will of the deceased.
Okay. So once the court does that, do I then, or does the estate executor just sort of takes it to a lawyer? Let's say if I had it that one of my investment property, was supposed to go to child A. How does the process of the transfer of those assets work? Because I think a couple of things I wanted to sort of look at is, one, I think you mentioned a couple of things. One is, there's estate administration tax or probate fees that has to be paid, for example. The second part of it is sometimes there might be capital gain implications on certain assets, for example, right? Do all of that need to be paid before sort of these assets can be passed on to that next generational beneficiaries per se?
So the estate administration tax, yes, that is paid with the application. Of course, if there's financial constraints, you can request to the court that the payment be deferred to when the trustee has access to the actual assets, but that's a different process. But the default is it's paid with the application.
Got it.
So from a practical point of view, what often happens is either if you know that they have money in the bank, the person who has passed away, you can go to the bank with a copy of the will, and usually accompanied by a letter from a lawyer, essentially saying that you're making this application and you require the money for the estate administration tax. And what you'll do is basically tell the court to make the draft payable directly to the Minister of Finance, but essentially directly to the court. So then at least they have a level of, hey, you're not going to take the money and run away kind of thing, right? So that's something if you have the money on your own, you can pay it out of your own money and then get reimbursed by the estate.
Okay.
Or if like I said, they have access to funds if they have money in the bank, you can try to make the payment from there. And then with respect to things like capital gains, all of that, usually what happens again, we'll speak practically because that's what everyone cares about. What will happen is so say for example, so now you have the certificate in your hand. What you do is you open what we call an estate bank account. So the bank account is in the name of the estate of so-and-so.
Yeah.
what will then happen is you essentially amalgamate all your assets, all the money in the bank, you amalgamate into that account. And then if there's any property that's being distributed, you do a transfer. Let's talk about real property. So you do a transfer of property A from the estate of so-and-so to whoever the beneficiary is.
Sure. And
the estate trustee has the authority to sign any documents on behalf of the estate. So they'll sign the documents. Usually what will happen before any funds can be distributed is the accountant will sort of hold back a certain amount of money that they think will, like based on their calculations, obviously, they think is going to be required for capital gains, going to be required to file the taxes, all of that. So usually what will happen is they'll hold back that portion, everything else is distributed in accordance with the will, and then as those amounts come up. So for example, capital gains, that'll be paid out of this amount that's held back. If the just general, you're right. So yeah, all of that. And then also you still have to make sure the personal taxes of that person is filed from the last time they filed until the date of their death. So you have to file their personal taxes and then you file the estate taxes. So normally the accountant will keep that holdback amount just to ensure that everything's paid out. And then once you find, like it is a long process, like once you finally get the return of the estate's taxes, then if there's anything outstanding, then you can distribute, like if there's out of that holdback, if there's funds remaining, then you distribute that in accordance with the will as well.
Got it. So the applications for the probate process is done with the courts. Courts give some type of certification. Typically, any type of fees that are associated with the estate administration tax has to be obviously paid to the court by the trustee. Once that will is probated by the courts, that's when sort of the changes of ownership and everything else will sort of happen at that point.
Yeah, so legally nothing can change hands until that certificate is granted. So we've had instances where, people have sold their property and then they passed away, unfortunately. And then you have this gap because now this closing is coming up and the person's not here to sign documents. So we would have to, on an urgent basis, go to the court and get that certificate, because if we don't have that certificate, that no one can sign on behalf of the person who passed away to actually effect a transfer. So without that certificate, you legally can't do anything.
Got it. So obviously we spoke quite a bit about the probating process. So all of this is based on there's a will that's actually active, obviously, that's valid at the end of the day, right? Talk to me a little bit about what happens if someone passed away without a will. I believe there's something called intestate law or law of succession, etc. Talk to us a little bit about what happens if someone passed away without a will.
Sure. So if you pass away without a will, your estate is governed by what we call the Succession Law Reform Act, which is an act in Ontario, which essentially has a section that deals with intestate passing, which means that you don't have a will. So if you look at it like this, in the will, you are specifically handpicking what you want to happen to your estate and your assets, When you pass away without a will, your beneficiaries are essentially governed by this act. And what the act says is if you're married, the first $350,000 of your will goes to your spouse. If you don't have children, they essentially get everything.
Okay.
If you have children, what will happen is the first $350,000 will still go to the spouse. Whatever is remaining is split equally amongst your children and your spouse. So say, for example, you have $1 million, your estate is valued at $1 million. Out of that $1 million, the first $350,000 will go to your spouse. And that $650,000 would be divided amongst, say you have 2 kids, so your 2 kids and your spouse, so it's divided into 1/3, 1/3, 1/3, and then it's distributed as such.
Got it.
Say you don't have a spouse and you don't have children, it goes to your parents.
Okay. Say
your parents are not alive, it goes to your siblings, and so on and so forth. The point is to find the closest kin, essentially. So, if not your siblings and your aunts and uncle, like as far as sort of as close as you can go, they'll try to find someone. The last resort is that basically the government gets to essentially, like the crown takes over your property.
Wow.
That's not common, especially in the Tamil community, because we have so many
always
relatives.
somebody,
We have so many relatives. But legally, that's what would happen. So whoever is the closest to you gets to be your beneficiary.
Got it. So a couple of things, I guess, to note on that is really, I mean, if you sort of pass away intestate, unfortunately, your wishes may not sort of be passed on or be acted upon unless there's an actual document. Some people who you didn't want to have or be giving your assets to might end up with with your assets at the end of the day.
Yeah, for sure. Like, so we've had situations where, like I had this one where they were husband and wife, and then they didn't ever get legally divorced, but they were separated for all intents and purposes. And he didn't have a will, and he didn't have children, so everything went to the spouse, which I don't know if he would have cared, because at the end of the day, they were together at one point. But of course, I'm sure, like, if he wanted it to go to other people, that opportunity was lost, because from a legal point of view, she is still the legal spouse and she has entitlement to the assets. So yeah, you don't get to choose who your assets go to. So yeah, you definitely don't get to choose your beneficiaries when you pass away without a will. You also don't get to choose your executor. It's the same thing. It's you can make an application based on sort of your relationship. Again, anyone can apply, but it's often usually the people that are also the beneficiaries, because why else is someone going to apply? So sometimes you have people that are not, we'll call it diligent enough to be a good estate trustee, but by default they get to be, because you don't have a will in place. The other thing with passing away without a will, on the probate side, is it just makes the process much more complicated. It's a little bit more, like the courts put a little bit more, let's say, emphasis on the process. They make it, there's much more documentation involved. It's a longer process when you don't have a will. There's also a requirement that sometimes you have to put up some security as in the form of a bond, which can get expensive, especially because it has to be, the value of the bond has to be twice the value of the estate.
Oh, wow.
Yeah,
okay.
So it can get pricey. And the other time, and you also by default need a bond if you don't have a will, if you have children under the age of 18 as beneficiaries. So it's just like, it doesn't make any sense not to have a will. Like, as odd as it sounds, like there's no reason not to have one. The benefits far outweigh any sort of drawback. To be honest, the only drawback is A, you have to think about death, and B, you have to pay to get a will done. But I think personally, and I of course I'm a lawyer, so I'm biased, but the benefit outweighs these two issues.
Especially when you pass away intestate, and let's say the whole process is sort of going on with the courts, with the application and all of that. Can that be contested? I mean, I'm assuming even a will can be contested, but I'm assuming if, let's say if somebody came and said, hey, I actually gave him XYZ dollars to be able to start a business, and these were all part of it, some of the assets were accumulated by, my support, etc. Those kind of process, does that come up often, or can that happen? Is it raising complications in scenarios like that?
Yes, but to answer that specific example, you don't address your debts in a will anyways. So, or debts and loans. So in the sense of people generally challenging it, yes, it gets easier to challenge when there is no will from the point of view of who's applying. So for example, if a friend is applying to be the estate trustee, because they know that they were a trustworthy person, they had the deceased would have wanted them to be the trustee. They really have no standing if you have, say, a spouse that's like, no, I want to apply instead. So it just gets there is more to there's more windows of opportunity for challenges when there is no will, because you have nothing, like everyone is almost like guessing what you wanted to do, right? So it is definitely easier to challenge when there's no will in place. Obviously, like you said, you can still challenge a will People will sometimes a beneficiary say, you had a child that you don't have a good relationship with or something, and you don't put them in their will. They'll challenge the validity of the will, saying like, he didn't understand what he was doing at the time, stuff like that. So there is definitely ways to challenge a will. There is equally as many ways to challenge when there is no will.
Got it. And just to quickly touch base on, can an executor be a beneficiary as well, or a trustee be a beneficiary as well?
Yes. So oftentimes, the most common example is, you say if something happens to me, everything goes to my spouse, but my spouse is also my beneficiary. They can be one and the same. Again, there's benefits of that and not. So the biggest benefit, and I tell my clients this as well, is when you have your executor who's also a beneficiary, in a way, you're almost ensuring that they are not going to waste any time or money because they're taking from their own pot. Do you get what I'm saying?
Yeah.
So I've had
vested interest.
Yeah. So it's the estate, and try to collect from the estate because your estate, as an estate trustee, in terms of obligations and responsibility, is to pay the funeral costs, the taxes, and the debts of the estate first before you can distribute any money. So that is an obligation that you do have as an estate trustee. So if there's unpaid credit cards, line of credits, mortgages, all of that, the estate is still responsible to pay. Now, from a practical point of view, a lot of, especially financial institutions, they kind of just write it off when you pass away. So, you'll advise the credit card companies. The credit card companies will ask for a copy of the debt certificate, and you don't sometimes sort of hear from them. Again, that's not that they're not entitled to. It's just, I don't know if they just don't think the process is worth it, whatever it is. Sometimes what they'll do is they'll sell it to a collections company, and a collections company will come after you. Yeah. So legally, yes, those debts still exist, and you are required to pay them.
Gotcha.
But if they choose not to, then that's sort of their
and I think
discretion.
The one last thing I'll sort of wrap up in the will side of it, I think we spoke about it and you alluded to a couple of times, everything from probate fees, taxes, funeral costs, everything else. I think the most important thing is it's one thing to have a will, but make sure it's funded as well at the end of the day, right? I mean, I know we often talk about not necessarily having enough liquid cash to be able to fund some of these things. I've read articles where sometimes baby boomers sort of get inherited cottages and things like that, and if they're not able to pay for those capital gain taxes and everything else, they'll end up having to liquidate some of those assets just so that they're able to sort of pay those fees at the end of the days. Yeah,
for sure. And again, like you said, if you don't have access to capital, a lot of things are not possible. So I get this question with respect to property. So they'll say, hey, I want my property to go to my children. Say if something happens to both of us, I want my property to go to my children. They need a place to live. And my answer to them is, that's fine. But from a practical point of view, if they can't afford the mortgage, or they not even just affording the mortgage, if they can't qualify for the mortgage, you might sometimes have to sell. They won't have any option to sell, but to sell, sorry. So, if you have mechanisms in place to get that liquid cash, like you're saying, to do things like pay off the mortgage if they need to, or pay capital gains, because otherwise they might not be able to actually hold these assets.
That's awesome. Quickly, just in the interest of time, let's just jump into power of attorneys at the end of the day, right? Talk to me a little bit about power of attorneys, what they are and what they're used for.
Sure. So, like how a will is for when you die, a power of attorney is for when you're alive. As soon as you die, any power of attorney you have is voided. Okay. There are two types of power of attorneys. There's one for property and there's one for personal care. Okay. Personal care is essentially like when you're in the hospital, say you're in a coma or something, and someone can make decisions on your behalf with respect to, your healthcare, your shelter, stuff like that. A power of attorney for property is for whoever you're granting as your power of attorney, the attorney, to have access to your assets. You can limit it as much as you want, or you can keep it as broad as you want. So some people will say, a power of attorney for property, you can pay my bills from my bank account, you can withdraw cash, but you can never take out cash. Things like that. You can limit it to, of course, protect yourself.
Sure.
But essentially the point is for them to have access to your assets, both financial, property, all of that. Those are the two types of power of attorneys. It's not something that everyone needs. Like a will, I think that everyone should have one.
Sure.
For a power of attorney, it's really based on a scenario or your life circumstances.
Sure.
Power of attorneys are often when you're older. To be honest, a lot of senior people will have powers of attorney because the chances of them, knock on wood, getting sick is much higher. So having a power of attorney for personal care makes sense on that side. And then on the property side, like I said, it's hard for them to go to the bank and it's hard for them to sort of do some things. So sometimes it's easier to give someone a power of attorney. The other instance where you would have a power of attorney is if you say you travel a lot or something, and you just want to make sure that someone else has access to your money and your bank accounts and all of that. But it's not something that I would say everyone needs to have. I think that if your scenario dictates, like I said, if you're either older or you're sick, unfortunately, sometimes it makes sense. The problem is there's a lot of abuse with power of attorneys, so it's not something that people just sort of give out and just sit back. It's really just on a scenario, like needs-based scenario. But that's essentially the point of a power of attorney, is to let someone act on your behalf in either your financials or your healthcare.
Gotcha. Just out of curiosity, I mean, I'm assuming, let's say if I get into an accident today and I'm unconscious and not able to, or I'm in coma, for example, if I don't have a power of attorney, is it usually the next of kin who sort of gets to make any type of decision when it comes to healthcare, etc., if I don't have a power of attorney?
Yes. Okay. So there's an act called the Healthcare Consent Act, which governs that exactly. So in the event that you don't have a power of attorney for personal care, but something does happen to you, your spouse can make those decisions. And obviously, speaking to your doctor, like your doctor is a professional, but your spouse can help with those decisions.
Perfect. So just if we were to break it down quickly, wills, God forbid, if something happens to you, how's your family taken care of? How are your assets sort of distributed? If you have minor children, how are they sort of taken care of? Who are going to be sort of the legal guardians for you? God forbid, if something was to happen. Obviously, the beneficiaries are who the assets would go to. But I would also assume, based on our conversation, the executor has a loaded role. At the end of the day, we want to make sure they're, have the capacity and the capabilities to be able to manage that entire estate. I mean, it's one thing if you have, let's say, one property and a couple of bank accounts, but if you have a couple of properties, now various things need to be taken into consideration when we sort of manage that, because they really need to be able to speak to the courts, the legal system, the accountants, etc. Power of attorney, on the other hand, while you're alive, if you're incapacitated for whatever reason, who gets to sort of help make a decision on your health care, as well as, for example, on property, and that doesn't necessarily have to be if you're incapacitated, but let's say you're traveling somewhere and you want someone to take care of, obviously, your banking, you would sort of have a power of attorney. That being said, the thing that you sort of alluded to is, hey, there might be abusive power of attorney as well. So we got to really be careful once you're granting someone that access to act on your behalf, that they can actually act on your behalf, but you can make sure it's either as broad as it can get or as narrow as it can get in terms of what they can actually act on.
Yeah.
The one last thing before I sort of let you go on this one, Gathya, when it comes to wills and power of attorney, are they sort of constructed from a provincial standpoint, meaning if I had assets across the country or even foreign assets, for example, when it comes to wills, do I need a will that's drafted in various different provinces or international, or is one will that I actually do in Ontario that'll actually cover me regardless of where I am?
So the short answer is yes, you would need different ones, because that your will that you write here only has jurisdiction here. So people will make reference to other assets, foreign assets in their will, but you have to ensure, because you are governed by the laws of wherever that property is, right? Okay. So, the most common example I always get is people that have property in Sri Lanka, right? Yep. So they'll say, listen, I have land in Sri Lanka. What do I do? I want to make sure that goes to my family. But the process and the rules around what happens to your property when you pass away in Sri Lanka is different than Ontario.
Gotcha.
So, you can make reference to it, but it holds no weight here.
Got it.
So you would still have to ensure that wherever your foreign assets are, you do a will, at least to make sure that you're in line with the rules there.
Got it.
So you would have a will there that says, upon my passing, this is what happens to my property. So yeah, you would need a separate will for that.
Awesome. And just one last thing, how often are these wills or power of attorneys sort of reviewed? I'm assuming it's not one of those things where you do it once and set it and dust it, but how often are they typically reviewed?
So power of attorney is not so often. It's really, again, you usually only do it on a needs basis. The most important thing about a power of attorney in terms of reviewing it is if you need to revoke it. So for example, once you're healthy or something and you don't need it anymore, sometimes it makes sense to revoke. But with respect to wills, what I always say is anytime you have a big life event, getting married is the biggest one I can tell you. Having children is another one. If somebody that's in your will passes away, those are the sorts of moments. If you buy big assets, like say I have a lot of clients where when they first made their will, it was the typical scenario. They have one house, they have one joint bank account, and that's sort of it. But now, as a community, we're doing much better. They now have multiple properties. They have investment properties and all of that. So it made sense for them to sort of review their will. So I would say anytime you have sort of big life events, take a look at your will just to make sure. So you might not have to make any changes, but that's usually a triggering reason for changing your will.
Yeah, especially I guess when you didn't have any kids, it would have been your primary beneficiary might have been your spouse and contingent might have been someone else, but now that kids are involved, maybe they become your new contingent beneficiaries.
Yeah, for sure, yeah.
Gathya, once again, thank you for joining us.
Of course, this is great.
Thank you.
Thank you.